Well, thank you. It's a great pleasure to be here, a great honor, especially with such a distinguished audience. I must say I first attended a NAPA event in 2013 with my wife, and she still recalls how wonderful it was. It was in the Napa Valley, of course, and the wine was very good, and the conversation even better. And some of the speeches were genuinely inspiring and shaped my work, so I'm profoundly grateful. Now, my goal today is to talk about the administrative state. Ordinarily, you might think administrative power is a boring topic. In fact, when I was in law school, I assiduously avoided taking the class on administrative law because I thought it was tedious. And when I went into practice in tax law, I again thought it was distinctively boring. So that's what I want to do today. I want to put you to sleep. But even if you are not interested in the administrative state, I assure you, it is interested in you. It's very interested in you. It is interested in regulating you. It is interested in demanding compliance measures. I think Jamie Dimon spends about $1 billion on compliance, can you believe it, each year. It's interested in imposing paperwork, and not just 1 or 2 pages, reams of paperwork. We just decided with some courage to hire a nanny and do it lawfully, something very unusual in the Upper West Side. Most people don't pay their taxes. I've yet to meet a fellow law professor who pays taxes. And I can't begin to describe to you the paperwork. We actually have a computerized service that takes care of us, because otherwise, although a law professor, former tax practitioner, I would not be able to get it right. So it's very interested in us. And it thereby interferes not only with your business, but also with your speech and your religion. In short, I think we have to consider the administrative state a threat to our freedom, a threat, in fact, to our civil liberties. And that's what this talk is about. Now, before I get started, forgive me, I'm a lawyer. I'm going to define my terms. You thought you'd escape such nonsense at a pleasant conference like this, but you won't. I want to explain what I mean by the administrative state, or in terms of the power, administrative power. It is, put simply, an attempt to bind us, to impose legal obligation on us through pathways different than those laid out in the Constitution. The Constitution places the power to bind, to control, exclusively in Congress and the courts. Only Congress can make legally binding rules. Only the courts can make legally binding adjudications. Nonetheless, various agencies, HHS, EPA, FDA, and so forth, attempt to make legally binding rules and adjudications, and this is administrative power. And you take it as a whole, that's the administrative state. Now, how do we think about this? One can think of it as a sort of off-road driving. Some of you probably have off-road vehicles, those 4-wheel things that look like a construction kit and go very fast on dirt, right? Where the Constitution lays out formal avenues for issuing edicts that bind Americans. But the government likes to go down other pathways. That is, it prefers to drive off-road. It pursues binding power down paths of its own choosing, not those laid out nicely by the Constitution. And this is exhilarating for those in the driver's seat. It's very exciting, but it's obviously a little disconcerting for the rest of us. We sometimes get run over. Now note that this administrative power not only stands in contrast to the Constitution's legislative and judicial powers, but also in contrast to its lawful executive power. The Constitution gives the executive great executive power to the president, and this is not merely the power to execute laws, but all the nation's lawful force. So this includes the power to prosecute criminals in courts, to distribute benefits, to determine the status of immigrants, and so forth. In contrast, administrative power is an attempt by government agencies to control, to bind Americans, to create legal obligation. Now, at the outset, I should just say, much regulation is valuable. I don't want to stand here and say regulation is bad. Some of it is bad, some of it is good. It depends what it does. But the regulation adopted not by Congress, but by the administrative state, HHS, EPA, and so forth, is very different from that adopted by Congress. It tends to be harsh. It tends to be indifferent to economic realities, and it tends to be hostile to local and especially religious sensibilities. And that's by design. That's not a bug, that's a feature. And the severity is what you'd expect when you don't act through elected representatives. And so I want to come to the focus of today's talk, that administrative power is a threat to civil liberties. For more than a century, people have opposed administrative power on the ground that, for example, it's bad for business. You've heard this now for over 100 years. But that's not a very principled argument. What's more, it's very incomplete. It's not just bad for business, it's bad for all of us, even as individuals. Since writing on the subject and running a civil liberties organization that litigates on this, I get phone calls, often in the middle of the night, or desperate emails. And sometimes it's from an investment advisor or a banker who spent all their savings defending themselves, let's say, before a state agency and now face a federal investigation. But more commonly, it's from people living on the street. It's from middle-class people or working-class people. For example, one guy, he had just lived in a trailer home, but he loved it, and the sheriffs bulldozed it without a warrant and took all his dogs whom he bred to make money. Just this week, I had an email from a doctor who was deprived of his license to practice medicine. He's living in a large industrial tire in a junkyard. He's lost his family, he's lost everything. Administrative power is very interested in us, and all of us, not just business. So the business angle is not a good argument against this. It's unprincipled and it's too narrow. Now, people have also argued against administrative power because it violates the separation of powers. That's true. That's not an argument that moves judges or lawyers. That just doesn't move people. It's a weak constitutional argument, in part because separation of powers seems so amorphous. So over the 20th century, this power has gone bigger and bigger. It's not bigger. It's no longer an exception. It's the main mode of government interaction with us. 9 out of 10 adjudications these days are not in the courts. They're in front of administrative agencies. It is said, I can't quite verify this, that 95% of criminal offenses are now defined by administrative regulation, not by statute. This is a little scary. So it's time for another approach, and that's what we're here to discuss today. Now, of course, if this morning in my constitutional law class, I would be asking you questions, and you would answer it. But since you didn't do the reading, I will have to recite it myself. We need to recognize this as a civil liberties problem. Now, you may think, no, that's not true. This is not a civil rights problem. You're just copying someone else's language. This is about separation of powers. Live with it. Well, nonsense. In fact, administrative power is the greatest single threat to civil liberties in our era. No single development in our legal system deprives more Americans of more constitutional rights. Now, traditionally, the most systematic threats to civil liberties came in attacks on particular groups, and this remains a problem. I don't want to disagree with that. But increasingly, there are also much broader threats that affect all of our liberties. And administrative power is the primary example of this broader threat. And that's why I think it's no exaggeration to say this is the greatest threat to civil liberties we face. So I want to run through 6 examples of this just to illustrate what I mean, to make it concrete. And by the time I've finished, you'll really need that coffee in the back. First, due process. I know you're not lawyers. Forgive me. I'm going to talk a lot of law. But as I said, you may not be interested in it, but it is interested in you. So some of you probably already need these arguments. So pay attention. Okay, first, due process. The administrative state repeatedly violates due process. The Fifth Amendment to the U.S. Constitution guarantees the due process of law. And this guarantee developed precisely to bar binding adjudication outside the courts, such as administrative adjudication. The principle of due process becomes constitutionally significant, no, not in 1791, but in the 14th century already, in English due process statutes, which bar binding prerogative or administrative adjudication. The principle stated at the head of the 1368 statute, in the Parliament rolls, this is just inserted on the side. It's not the official title, but it's a 14th century attempt to summarize the statute, which is long, so I'm glad to have the summary. It says, none shall be put to answer without due process of law, that meaning in the courts of law. They can't even ask you a question or demand information without a court order. Americans guaranteed this in the Fifth Amendment. And interestingly, we have an early academic commentator on this. St. George Tucker lectures on the Bill of Rights at William and Mary in the 1790s, from 1791 onwards. And he quotes the Due Process Clause of the Fifth Amendment and concludes, and I quote, "Due process of law must then be had before a judicial court or a judicial magistrate." In other words, it doesn't come in an agency. Similarly, Chancellor James Kent at Columbia, where I teach, explains the due process of law means law in its regular course of administration through the courts of law. Nonetheless, the government nowadays in administrative proceedings regularly violates this. Most basically, agencies impose binding adjudication outside the courts without real judges. They're called administrative law judges. They're not judges. They issue summons, subpoenas, warrants, and fines without the due process of law. They deny equal discovery as required by due process, where you have proceedings that are civil in nature. They impose prosecutorial discovery, which is forbidden by due process in cases criminal in nature. And they even reverse the burdens of proof and persuasion as required by due process. So your procedural rights are perpetually violated every day by these agencies. I'll take one example. The Securities Exchange Commission, right here in town, can seek proceedings against you in U.S. district courts. Do they regularly do that? Well, only when they think they're really going to win. When they think they're going to lose in court, it's very convenient. They have their own courts. Cisneri, the head of enforcement at the SEC, to the summer of 2014, actually boasted, "We don't have to worry about juries. We can have our own courts." That suddenly got people's attention as to why there might be a danger in all of this. So it can choose to proceed against you in an administrative tribunal held by an administrative law judge, who's not a judge, who's selected precisely for his or her bias in favor of the SEC. And by the way, I can prove that in painful detail. The bias is real. Who denies you regular due process, who even forces defendants to prove their innocence. So one SEC administrative law judge has boasted that he has never held against the SEC. Can you imagine? And he tells defendants, "You might want to settle and spare us a lot of trouble because I've never held against the agency. Want to roll the dice?" Seriously, this is recorded. Another recently quit and wrote in the Wall Street Journal that she quit because the commissioners were pressuring her to decide in their favor. This is standard fare in the administrative state, and it's a violation of due process. Second, jury rights. The administrative state repeatedly denies jury rights. Like due process, jury rights bar binding adjudication outside the courts. You're guaranteed a jury in both civil and criminal cases by the Constitution. And where can you get a jury? You can only get a jury in a court, a real court. So the right to a jury precludes adjudication outside the courts. And in fact, we have some of the earliest decisions, constitutional decisions in the United States, in New Jersey and New Hampshire in the 1780s, hold that administrative proceedings are unconstitutional for violating the right to a jury. New Hampshire courts, which was in the middle of nowhere, by the way, New Hampshire is really the sticks in the 1780s, their judges nonetheless hold 6 times in 6 different cases in 1786 that the right to a jury is violated by administrative proceedings. But the Supreme Court shuts its eyes to this. They justify administrative denials of a jury on the bizarre theory that the government has, get this, public rights which defeat your private assertion of your constitutional right to a jury. It's utter nonsense, but that's the state of our doctrine these days. So, for example, the Federal Trade Commission, I'm just taking one of dozens here, brings proceedings against you before administrative law judges who act without a jury. So your jury rights just, poof, disappear when they choose to act against you outside the courts. Third, judicial violations of procedural rights. So you might think, oh, it's just a problem in the administrative state. When you appeal to a real court, you're okay, right? There, you get your jury. There, you get due process. Well, not quite, because the courts have sought to defend the administrative state, and to do that, they have to violate your rights all over again. So we have a double violation of rights, first in the agencies and in the courts. For example, you might think you get a jury when you get to court. Well, you don't get a jury when you appeal from an agency because the courts defer to agency fact-finding. When a court reviews an agency adjudication, the judges rely on the agency's fact-finding, preserved in its administrative record, which is just one party's account of the facts. And this deprives private parties of their right to a jury trial. Now, as it happens, jury trials are a right in the first instance, not just on appeal. And this, again, is recognized by early constitutional cases. But even after you appeal from an administrative agency to a court, you still don't get your jury. Even worse, when you appeal from an agency to a court, the judges are required to be biased against you. Now, I know you may think this is improbable. We all know some federal judges, and they tend to be models of probity. They're nice people. They're not unfair. I shouldn't be bad-mouthing them, and I'm not, because personally, they go out of their way to be just. But the Supreme Court has required judges institutionally to defer to agency fact-finding and agency interpretations of law. So as a result, the judges, whatever their personal probity, must abandon their duty to decide for themselves and instead to defer to the agencies. And this is especially shocking when the government is a party to a case. People have analyzed this for 20 or 30 years and worried about it in terms of separation of powers. Instead, what you need to do is think about it in terms of due process. Because when the government is a party to a case, the judges are pre-committed by deference to favor one party's version of the facts, the government's version, and one party's interpretation of the law, the government's interpretation. So the judges are required to be biased in favor of the most powerful of parties and against us, ordinary Americans. This systematic judicial bias in violation of the due process of law, it's probably the most shocking violation of due process in the nation's history, other than in connection with slavery in the 19th century. This is going to destroy the reputation of the federal judiciary. They know it. They're backpedaling as fast as they can. I'm glad to say I played some role in forcing them to backpedal, but it is deeply disturbing. Put another way, there are two types, first year law school, there are two types of questions in any case. Questions of fact, questions of law. So when there's institutionalized judicial bias in favor of the government on both the law and the facts, what's left for unbiased judgment? Why bother going to court? So the courts have corrupted their own process in their attempt to defend administrative process. Okay, this sounds, you get my idea that this is a civil rights problem. It gets worse. It's going to get worse with each step. And if it seems like my goal is to shock you, it's not my nature to try to shock people. I'm a pretty mild-mannered guy. It's not my typical mode. But this topic is shocking. We're in a terrible state legally. So next, consider the transformation of procedural guarantees into options for government power. There's been a conceptual change which sounds theoretical, but is sobering. The government once could engage in binding adjudication against us only through the courts and their judges, but now it can choose, right? It's ambidextrous. It can either go through the courts, if they feel like it, they can go through their own agency adjudicators, and not their due process, but their faux process. And that changes the very nature of procedural rights. Most of the Bill of Rights, is just procedural. So this changes the nature of the Bill of Rights almost as a whole. Those rights listed there once were guarantees, assurances against government. Now they're just one of the choices for the government in its exercise of power. It can take you to the courts where it has to respect those rights, or it can go through its own byways, the administrative judges, and it doesn't have to give you those rights. And procedural rights have thereby been transformed. They're no longer guarantees, they're just options for the government. And it's difficult to think of a more serious civil liberties problem for the 21st century. Next, does it get worse? Yes. Let's think of the costs for substantive rights. And this is how I got into this. I was bored by administrative power, but I worry a lot about religion and about science and the freedom of both. They both need to be free. These are ultimate things that deserve our solicitude. And friends of mine were being silenced, both in religion and in science. And so slowly, it occurred to me, someone has to do something about this, and my first goal was to get others to do something about it because I was too bored by administrative power. But as you'll see, it is interesting, disturbingly so, and I got involved. So let's start with religion. The Internal Revenue Service suppresses religion through Section 501c3. Okay, that will turn off everybody. There's a revenue subsection. How can it be interesting? 501c3, as many of you know, however, is a mode of regulating nonprofits, particularly churches. It's really, I know it's called nonprofits. Think of them as churches and churchy organizations. It enables the IRS to license religious speakers and religious speech in politics. 501c3 restricts churches in two types of speech, election speech and lobbying speech. In other words, your choice of legislators and what they legislate. Now, a tax lawyer, and I used to hang out with them, remember, will tell you, oh, don't worry. Section 501c3, that's just a technical tax provision. It's designed to prevent a pass-through of money that gets favorable tax treatment into politics. And you wouldn't want federal subsidies for political speech, would you? So really, don't worry too much. Well, that's not really just what it does. The pair of speech restrictions, 501c3, were first proposed by, not a tax specialist, but by someone you've never heard of, I bet. Have any of you heard of Hiram Evans? Raise your hand. Hiram Evans, in 1930, proposes that pair of speech restrictions, particularly on churches. Who was he? He was from Dallas, Texas. He was a dentist with a broad, winning smile. He was a very smart man, theologically liberal and opposed to orthodoxies. At one point, a little club he belonged to, known as the Ku Klux Klan, he was part of its Dallas chapter, took a very nice man who was a bellhop in a hotel and happened to be the wrong color, dragged him down to the river, whipped him, and using acid, probably obtained from the dental office, burned letters KKK into his forehead. For this act of literacy, Hiram Evans was elevated the next year to be the imperial wizard of the KKK. I spend a lot of my time studying the KKK. It's a much more interesting organization than most people understand. Any case, he, in 1930, proposes these two limits on churches. This is not a sanitary endeavor. The Hiram Evans involvement does not mean it's unconstitutional, but it's enough, I think, to shock even tax lawyers to thinking twice. The KKK as a whole was theologically liberal. That's how Hiram Evans made it a national organization, in that it resented all claims of church authority, prototypically the authority of the Catholic Church. And in worrying about ecclesiastical authority in politics, Hiram Evans proposed what becomes these speech limitations. And the result has been administrative control of speech, particularly religious speech in politics. And that is, of course, the administrative suppression of speech about ultimate things. One of my hopes is to make sure that 501c3 gets cleaned up. Let's put it that way. Now, the administrative state in censoring ultimate things doesn't just go after religion. It also silences science through institutional review boards. How many of you have heard of IRBs or institutional review boards? Yeah, oh, fantastic. I hope you're not in the biomedical sciences, because then you'll know just how severe this is. HHS, Health and Human Services, that agency that always is trying to help us, insists that universities establish IRBs, or institutional review boards. And the boards are designed to censor speech in academic research and to censor the publication of research. HHS says the censorship protects individuals from dangerous scientists. We academics are so dangerous. But the evidence doesn't support this. There's very little evidence that IRBs save any lives at all. But instead, the evidence does show quite clearly that the censorship kills people in actually quite considerable numbers. When you suppress scientific inquiry and publication, oddly enough, people die. And by the way, often it's minorities who die, because the government's particularly solicitous of minorities. So if you want to do, for example, black men, something I've written about, black men have a much higher death rate when they go on the operating table for cardiac surgery. Much higher death rate than than white men. Why is that? And there are multiple possible reasons, and it's hard to separate it all out, but one reason may be bias. Doctors tend to be interested in interesting patients, and if you're low status or not interesting, they might pay less attention. I know this because when I see my doctor, he's, oh, professor, and so we spend half an hour chatting before I can get him, to look at an elbow that hurts or something. So that racism may be part of it, but clearly another part of it are IRBs. If I want to study death rates on the operating table in cardiac surgery, and particularly death rates of blacks, do you know how much review I have to go through? They don't want to let this through because that's too great a burden on black human subjects. Net result, more black deaths. It's really that simple. You try to protect, or pregnant women. My wife, when pregnant, needs some medicine for her sake and the baby. Do we know how much? Haven't got a clue. Too much is bad, very bad. Too little is bad, very bad. You can't study it. Pregnant women, oh, we have to protect everybody. Protections are good, but through censorship, not good at all. Then you're silencing people. I'll give you an example of this. It's very hard to measure the death rate, but it's clearly enormous. So in 2003, a guy called Pronovost, a distinguished scientist at Johns Hopkins, studies hand washing by surgeons in a very dangerous sort of surgery. I won't bore you with the details. Involves putting a catheter in the heart. There's a 2/3 death rate in every in operations, but it's better than 100% death rate. So you do these put in these catheters. He has an idea. It's mind-blowingly sophisticated. He says, "Have you washed your hands first, doctor?" Oh, whoops, and then they wash their hands. So it's a study where he gets them to wash their hands, and 1,500 patients are saved in the course of the study alone. Since then, HHS has acknowledged this saves the publication of the study, which fortunately got published, notwithstanding the efforts of the government, saves 17,000 patients a year in the US alone. Worldwide, it's much higher. In other words, that's 272,000 lives saved by the publication of the study to date. It's a simple study just involving washing your hands. But HHS thought that the research should have been suppressed. It should never have happened because it didn't have prior sufficient review by Institutional Review Board. The IRB hadn't done its job. And he was scolded by HHS for doing this. Now think of all the studies that we don't know about. Think how many hundreds of thousands, millions of lives per year get suppressed. We're all living shorter lives because of institutional review boards. In suppressing both religious and scientific speech, the administrative state proves that it is an abomination. You can be secular, you can be religious, but if you're concerned about ultimate things, you have a lot to worry about. And of course, that includes your own life. Last but not least, I don't want to put you all to sleep, but I want to talk about perhaps the worst part of all of this. You might be thinking, what could be worse? Well, let's talk about equal voting rights. The most basic administrative assault on civil liberties concerns equal voting rights. There are two preeminent developments in the federal government since the Civil War: voting rights and the administrative state. And so you have to ask, are they connected? Federal law was slow to protect equal suffrage. In 1870, blacks get voting rights. 1920, women get voting rights. 1965, voting rights for blacks begins to become a widespread reality. It's very slow. Interestingly, administrative power tends to expand in the wake of expanded suffrage. This curiosity is first noted to some degree by Thomas West, and I've expanded on it. The explanation's not hard to find. Equal suffrage was widely accepted, but the results provoked misgivings. When educated Americans worried about the boisterousness of representative politics, about the tendency of newly enfranchised groups to reject progressive reforms, what did they do? They sought a more elevated mode of government in which educated Americans were more dominant. So some early progressives were quite candid about this. Woodrow Wilson, my favorite early advocate of administrative power, he's in fact the granddaddy of American administrative power. He complains, and I must say, these are his words, do not attribute them to me. He says, the reformer is bewildered by the need to persuade a voting majority of several million. And he especially worries about the diversity of the nation, which meant that the reformer needed to influence the mind not of Americans of the older stocks only, but also of Irishmen, of Germans, and of Negroes. And he elaborates this point. In order to get a footing for new doctrine, one must influence minds cast in every mold of race, minds inheriting every bias of environment, warped by the histories of a score of different nations, warmed or chilled, closed or expanded by almost every climate of the globe. Charming, isn't he? So rather than try to persuade such persons, Wilson welcomes administrative governance. The people can still have their republic, but much legislative power would be shifted out of an elected body into the hands of, well, you know, the right sort of people. Now, far from being just a matter of racism, this has been a transfer of legislative power to the knowledge class. meaning not a class defined in Marxist terms, nor even to a class that is really especially knowledgeable, but to those persons whose identity or sense of self-worth centers on their knowledge, especially their academic university-style knowledge. And in appreciating the authority they attribute to their knowledge and distrusting the tumultuous politics of a diverse people, they've gradually moved legislative power out of Congress into administrative agencies to be exercised in more genteel ways by people, well, you know, like themselves. In short, the enfranchised masses disappointed those who knew better. Now, of course, when legislative power is removed from the representatives of diverse people, there are implications for minorities. So leaving aside Wilson's overt racism, and I don't think administrative power is necessarily racist, that's just its beginnings, the problem really is the relocation of lawmaking power a step further away from the people and into the hands of a relatively homogenized class. So even when it's exercised with solicitude for minorities, it's a sort of power exercised from above, and those who dominate the administrative state have always been, if not white men, at least members of the knowledge class. I guess, I mean, we're all members of the knowledge class, aren't we? But just some of us have false consciousness. Forgive me, it's a little Marxist joke. So administrative power cannot be understood apart from equal voting rights. Although the redistribution of legislative power has gratified the knowledge class, it makes a mockery of the struggle for equal voting rights. It reduces equal voting rights to sort of bait and switch and confirms the threat to civil liberties. Put another way, we live in a society in which the retail deprivation of one single voting right is an abomination, right? But the wholesale undercutting of voting rights by shifting legislative power out of the elected body, that's just fine. So just to summarize, administrative power is a profound threat to civil liberties. It denies the due process of law. It violates jury rights. It corrupts not only administrative process, but judicial process. It transforms procedural rights from guarantees for the people into mere options for government. It undermines substantive rights such as speech and religion. And last but not least, it undermines equal voting rights. This is the fate of our freedom. I want to close with a final question. What can we do about this? I know a lot of people who just say, can't do anything about it. Well, and I just can't live with that. I also happen to think it's wrong, demonstrably wrong. Most basically, we need candor. Words matter. By talking candidly about the administrative state, by talking not about administrative law, but about administrative power, not administrative law judges, but administrative decision makers and down the line, we can understand it, we can delegitimize it, and we can defeat it. And that's why I'm so glad to be here. I'm deeply grateful for this invitation to be here talking with you. The more of us who recognize the problem and talk about it, the sooner it will be fixed. So that's why I'm glad to be here. Now, I'll say one more thing, which is we also need more than talk. We also need litigation. I used not to like litigation. I didn't want to be a litigator when I was young. I'd rather be a tax lawyer. It's more pleasant. Why be so aggressive? I've changed my tune. I kind of like it now. And to that end, I recently started, this is very improbable for me, anyone who knows me, I talk with the dead, I write for the dead, my conversations are with people who are centuries old, dead and underground, and that's fine with me. I prefer reading what they have to say than contemporaries. But I recently came out of my shell and started a new civil liberties organization. It's called the New Civil Liberties Alliance, or NCLA. It almost sounds like a basketball team. And NCLA engages in strategic litigation to destroy administrative power and restore our constitutional freedoms. You can think of us as an alternative to the ACLU. We do what it will not. We attack the real administrative threats to civil liberties. We had two very pleasant successes in the Supreme Court this summer. We persuaded the Trump administration to adopt executive orders against guidance. In the first year, we're already having massive successes. And this is a joy. I can't tell you how much fun it is. We're taking down the administrative state, one unlawful power after another, until it will no longer be able to threaten us and our freedoms. So there's a movement afoot. I encourage you to enjoy it. It's going to be fun. There'll be alcohol as well as litigation. Thank you.